All right. Good evening again. And after 2 years of all of us being on Zoom, we still have technical difficulties. However, we are in for a great treat tonight, and I'm so glad that all of you have decided to spend this evening with the Illinois Judicial Council as well as the National Pan-Hellenic Council to receive some very valuable legal information and resources. Thank you. And with this, I will introduce Mr. Malcolm Whiteside.
Greetings, everyone. I'm so excited to see this council and judiciary council together. Judge Lyle, good to see you. We go back many years. But my name is Malcolm Whiteside Jr. I'm the president of the National Pan-Hellenic Council of Chicago. We are the largest council in the country, which is made up of the Divine Nine. And for those of you who do not know who the Divine Nine are, we are historically Black Greek organizations of fraternities and sororities, made up of 9 organizations. You have Alpha Phi Alpha, Alpha Kappa Alpha, Kappa Alpha Psi, Delta Sigma Theta, Omega Psi Phi, Phi Beta Sigma, Zeta Phi Beta, Sigma Gamma Rho, and Iota Phi Theta. And our NPHC mission is always been service to the community. And that is something we strive on. The last couple of years have been a real challenge due to the pandemic, but even during the pandemic, we still helped out. During the COVID, we was able to pass out masks, gloves, anything we could do to help out the community in that way. We participated in food giveaways. We also got very much in deep during the voter registration drive. But our core mission, social injustice, education reform, Black health, and supporting Black businesses. That has been our core mission, especially here in Chicago. And also community engagement. For those who didn't know, this past Saturday, we hosted a law enforcement panel at the Judicial Museum. And I'm not just talking local law enforcement. We had the head of every Illinois department that was here, from FBI, ATF, DEA, the prison reform director, Illinois State Police, the superintendent, and the Cook County Sheriff. It was very well informed, and NPHC Chicago will be putting the video of that panel on our site, so I will share that with everyone once that is up. But tonight, awesome night. I'm looking forward to this awesome partnership we have with the Illinois Judicial Council. Is to bring judicial awareness. But most important, look at your panel, judges who look like us. And that is such a key. And tonight, we're going to talk about evictions, foreclosures, and bankruptcy. But there's 3 more panels too, don't forget. I want you to write those dates down. On March the 16th, it'll be domestic relations and domestic violence. On March 23rd, it'll be child protection and juvenile justice. On March 30th, got traffic, pretrial, and criminal law. Now, just a little house rules. These are judges, not lawyers. So they're going to provide you with, they will not provide you with legal advice. This is a form of information. If you need legal advice, please call your attorney. They are the ones who you get advice for on the subject matter. But I want to thank you. Hope this information you hear the next 4 weeks will be helpful. And at this time, I would like to introduce Illinois Judicial Council President, the Honorable Judge Benita Coleman.
I need to unmute there. Good evening. Thank you, Mr. Whiteside. I am Judge Benita Coleman, President of the Illinois Judicial Council. Welcome to our program, Judges in the Community. And before I begin, I want to say thank you, Mr. Whiteside, to you as the President of the National Pan-Hellenic Council of Chicago, as well as your organization, for assisting us with providing this information these presentations to the community at large. So thank you for that. The Illinois Judicial Council is an association of predominantly African-American judges. Our members consist of judges on the federal, state levels, and also administrative law judges. Our theme this year is strengthen our foundation to empower and uplift our community. Each and every one of the attendees here tonight at some point has had a legal problem, whether it was simply having to deal with a traffic ticket or a criminal charge, as going through a process of a divorce or dealing with a bankruptcy. If you haven't had any of these experiences or haven't had to deal with the legal system, then I'm sure you know someone who has. Knowledge is power. Our goal with these presentations is to provide you with information about legal resources available to you that will empower you when addressing legal matters. Each one of our presenting judges have presided over cases in the area that they will speak about. Tonight's presenters, as Mr. Whiteside has already said to you, will be about bankruptcy, foreclosure, and evictions. And I am going to go ahead and also repeat the next upcoming seminars because I believe that repetition leads to knowledge and remembering what is to come. So on March 16th, our topics again will include domestic relations and domestic violence. On March 23rd, child protection and juvenile justice. And on March 30th, traffic, pretrial, and criminal law. The next voice that you will hear is Judge Tiana Blakely. She will provide to you an overview, a short overview of the court process. Thank you all for attending tonight and enjoy the presentation.
Good evening again, everyone. And thank you for joining. You're going to hear that several times. Just wanted to give you a brief overview of our court system. Cook County is one of the largest unified court systems in the world. Our Cook County courts here are headed by Judge Tim Evans. He's the chief of the Cook County courts. Throughout Cook County, there are various divisions and districts here to serve the residents of our county. We have some of the more familiar ones would be traffic, criminal, domestic relations, evictions, chancery, which includes foreclosures, probate, the law division. We also have our municipal divisions, which serve the suburban areas. We have Skokie, the Rolling Meadows Courthouse, Maywood, Bridgeview, and Markham. Now, what we are trying to do over the next couple of weeks is try to cover some of the areas where most people have questions about, the areas that most of us come into contact with. So that's how we decided on the areas to present to our community. But of course, there are very many other areas that we could cover, but we try to address the issues that we think affect our community the most. So I just wanted to take some time. Although we're at the end of this pandemic and we've been going through it for 2 years now, and court has been on Zoom. However, while the world is opening up, we know that Zoom is here to stay. We've learned something and Zoom is here to stay. The court system wants to provide access to justice, so Zoom will be here. So I want to just give you all just some information that could benefit you, maybe your neighbor, maybe a loved one, just about how to deal with Zoom court, Zoom etiquette. And even if you're presenting in person, some things that you need to be aware of. And I will be dropping various websites and resources throughout the presentation in the chat. So if you receive a subpoena to go to court, a summons, or anything, even if it's jury duty, you need to get to court. There's information on the Chief Judge's website. That information it details every court in Cook County. It has their Zoom web ID as well as the password. I will drop that in the chat later. So you can access all courts in Cook County via Zoom. There are some courts that are in person or has a hybrid. They have a hybrid. So some are in person or you can appear via Zoom. If you do decide to appear via Zoom, remember, you are still in court. You might be in your car, you may be at home, you may be at work, you may be in a grocery store. We have seen it all. However, it's still court. So you want to have the appropriate decorum when you appear on Zoom. You want to make sure that your devices are muted. You want to wait until the judge addresses you or the clerk addresses you. You don't want to yell out. You don't want your device to say Pookie or iPhone, because we don't know you by those names. We know the names that are on the dockets. So we want you to be aware of that. Another recent issue that's come up, and it's not in every court, but I just want you to be aware of it while I do have everyone's attention, is people are being spammed on Zoom. So you have people logging into Zoom courts and they're telling the attendees, I'm an attorney, I'm the state's attorney, I'm the clerk, I work for the court, and if you just can send me an Apple Pay, all charges will be dismissed or your eviction will go away, and people are falling for this. Unfortunate. I know you all may be even laughing and it sounds unbelievable, but some desperate times calls for desperate measures. So people have been spammed. So remember that, or tell your loved ones, if they do log onto a Zoom, your case does not go away by sending anyone Cash App, Apple Pay, Google Pay. So that's something else to remember. As far as next court dates, we get a lot of people, well, I didn't know where to go. I didn't know the clerks are not answering their phone and things of that nature. I'm going to also drop in our clerks, the circuit clerks website, so that you can have that information. If you have to go to probate, downtown, Skokie, wherever you need to go, you can call that clerk's office to gain information on your case, and hopefully they can provide you with your appropriate court date. You don't want to miss court dates. You don't want to receive warrants. You don't want to receive judgments just because you didn't show. It's very important, as these judges will tell you, no matter what, just show up. It doesn't go away because you don't show up. So again, I'm happy to be on this panel. I'm happy about the judges who are here tonight. They will all speak. We'll start off with Judge LaShonda Hunt, who's our judge in the federal court, bankruptcy court, and she's going to speak to us about bankruptcy. We'll then follow with Judge James Wright, who will speak on evictions, and then Judge Fredrina Lyle, who will then speak on foreclosures. At the end of the presentation, feel free to drop questions, or throughout the presentation, to drop questions in the chat, and we will try our best to answer those questions. And again, as Mr. Whiteside let you all know, we are judges. We are only here to provide information, give you procedural information. We will provide you with resources, legal aid clinics, and just different websites or community groups that you can reach out to if you need further legal advice. So again, as a disclaimer, we are not here to provide legal advice or to tell you how to move forward in any case that you have going on, only to provide legal information. Thank you. And with that, I'll turn it over to Judge LaShonda Hunt.
Thank you so much, Judge Blakely, and good evening to everyone. Thank you so much for having me. I'm excited to be here as a part of the Illinois Judicial Council and as a member of the Divine Nine. I'm a Delta Chicago alumni chapter, and so I'm really glad that we're doing this, reaching out to help the community. So, you know, I'm the different one here because I sit on the federal court in the bankruptcy court. I've been a bankruptcy judge here in Chicago for about 5 years. I'm a native Chicagoan, grew up on the South Side. So I get a real sense of pleasure and joy out of being able to give back to the community in that way. The bankruptcy courts are the least diverse courts out of all the federal courts. And so it is very important oftentimes when people come to court that they see someone who looks like them. So I'm going to go very quickly. I'll just do a very quick overview of just the highlights of bankruptcy court. Judge Blakely will drop in the chat, or I'll drop in the chat at some point, some resources that explain the bankruptcy process and that also give you a couple of timelines that show you how these cases tend to proceed. But I cannot stress enough, and I know the other judges will as well, that knowledge is power, and you have to know and understand what's going on in your case. Otherwise, you're going to have some real problems here. So let me just start and give a very quick overview of the bankruptcy court, and I'll do the who, what, where, so that I hit all of them. So what is the bankruptcy court? The bankruptcy court is basically a specialized federal court. So on the federal court level, you have the trial court, which is the district court, and then you have the Court of Appeals, and then you have the United States Supreme Court. So the bankruptcy court is actually a subset of the district court, which is the trial court. The district court actually has jurisdiction, meaning the authority to hear bankruptcy cases, but they have referred that to the bankruptcy court. So I only hear bankruptcy cases. And they are cases that either arise under the federal bankruptcy statute, or they are related to a bankruptcy case. So it's a court of very limited jurisdiction. That doesn't mean that I don't get overlap. I see issues involving evictions, foreclosures, family law, real estate issues, all of that. But those are the only types of cases that I am authorized to hear are those bankruptcy cases. So where do I sit? In the Northern District of Illinois. So the Northern District of Illinois pretty much covers the top half of the state of Illinois. So we have Cook, Will, Grundy, Lake, DuPage, Kane, all of those counties, and Rockford. There are 9 judges that sit in Chicago. I'm one of those judges. And then there's 1 judge who sits in Rockford. So the territory is wide and it is broad. We cover a lot of cases. Who are the judges? We are not elected, so you won't see my name on a ballot. I always feel for my state court brethren, and I make sure to vote for all of you because I'm appointed. I was appointed to a 14-year term by the Court of Appeals, and so I don't have to run. That's the difference a little bit with the federal court system. How does the bankruptcy process work? It seems like a mystery. There are a lot of complex rules, complex regulations, requirements that you have to follow. So there are 2 basic kinds of cases that I tend to see mostly involving individuals. There's a Chapter 7, which can be actually an individual or a business. That's a liquidation. What that means is basically a Chapter 7 trustee will take your assets, sell them, and distribute the proceeds to your creditors. You file a Chapter 7 because you can't pay your debts. A Chapter 13 plan, in contrast, is a repayment plan, individuals only. That means you have a regular and steady income. It can be unemployment, it can be Social Security, it can be a job, but you have regular income and you're able to repay your debts. The difference is that a Chapter 7 might last for 90 days, and then it should end. A Chapter 13 is 3 to 5 years of paying money to a Chapter 13 trustee who will then distribute it to your creditors. So those are the 2 basic types of cases that I hear. Sometimes individuals will need to file a Chapter 11. That's usually a business reorganization, so close to a Chapter 13, but individuals sometimes have to file a Chapter 11 because they don't qualify for a Chapter 13. There are debt limits that are provided under the bankruptcy code. And so if you have a high net worth, or you have property, or you own businesses, sometimes you can file an individual Chapter 11. It is quite a bit more expensive to do that, a lot more complicated. And so that's why it's important to talk to a lawyer about what your options are. All right. Why? What's kind of the goal of the bankruptcy court? In the bankruptcy court, there are a couple of really important goals that we are trying to achieve. So first and foremost, there is this concept that there should be this equitable distribution of all of your assets. All that means is we're going to avoid the race to the courthouse where one creditor gets there first. They're able to take everything that you've got, garnish your wages, and then there's nothing left over to repay your other creditors. And so what the bankruptcy process is designed to do is to have this orderly situation where a debtor files for bankruptcy. an automatic stay kicks in. The automatic stay is extremely important because that's how you stop creditors from trying to take legal action or any other type of action against you as a debtor. The automatic stay kicks in the moment the petition is filed. And that's usually why we see individuals filing for bankruptcy. They're trying to stop an eviction. They're trying to stop a foreclosure. They're trying to stop a wage garnishment. Their vehicle has been repossessed. Those are the common reasons why we see bankruptcy cases being filed by individuals. For businesses, smaller businesses, it's usually they can't afford to pay their debts. And if the owner has signed personal guarantees, then they're concerned about their own personal liability. And so that's why we tend to see these cases being filed. And so the thought process is that you need an orderly way to set this up and to decide if there are assets that need to be distributed to creditors, how that should happen. And so the goal is, once you get through that process, then the debtor is entitled to what's called a discharge. That means your personal liability for those debts is extinguished, it's wiped out, but not every debt can be discharged. So government fines, City of Chicago parking tickets, Illinois tollway debts are usually not dischargeable. So a bankruptcy case a Chapter 7 case, I should say, will not help you. They are dischargeable in a Chapter 13. That's why it's important to know the differences between the two. Some tax debts are not dischargeable. Student loans, that's a big one. You have to file a separate complaint and meet a really high standard in order to have your student loans discharged. And so that's another thing. If you're filing for bankruptcy, you want to think about how might those be treated in a bankruptcy case. But so there's that first goal of equitable distribution of assets, but then there's the second issue, the honest but unfortunate debtor. That's what the U.S. Supreme Court has said. That is who is entitled to bankruptcy relief. And one of the big issues is inaccurate disclosures of financial interests. A trustee will look into every crack and every crevice, examine every bank statement to see what money did you have before you filed for bankruptcy. And if you're not truthful, or if your disclosures are spotty, then you might not be entitled to a discharge. So those are, two of the main concepts that underlie the bankruptcy process. And then finally, let me just, give a piece of advice before I turn things over. Seek legal advice before you file for bankruptcy. Judge Blakely dropped into the chat a couple of links to our court website. There is a pro se help desk that the bankruptcy court offers. We don't run it, Legal Aid Chicago runs it, but I strongly encourage you to get legal advice. Talk to someone about what you're trying to accomplish, whether a bankruptcy will help you, because you do take a hit on your credit report when you file for bankruptcy, and you are limited to a certain number of discharges within a particular number of years. And so it's not necessarily a remedy that will clear up everything, but it can be helpful for someone who is looking for a fresh start and feels like this is the only way to do it. So I'll stop there and turn it over. And then if you have more specific questions, you can ask those once the presenters are done. Thank you.
Thank you, Judge Hunt, for that valuable information. We will now proceed with Judge James Wright, and he will address evictions. And again, if you guys have questions, please feel free throughout the presentation to drop them in the Q&A, and we will address your questions if we are able to.
Thank you, Judge Blakely and Madam President, all my esteemed colleagues. I am happy to be here. I'm in the eviction court, and let me just say a few things. I'm going to give a broad overview of the eviction court. But first and foremost, I need everyone to understand, because I'm sure I've got landlords here and tenants, so we have interests on both sides. But understand that because you come into the eviction court, that should not be a stigma or a sign of something that someone has done something wrong.
You need to understand that, because sometimes people come in the eviction court for reasons unattributed to anything that they've done. I've had cases where a person came in for eviction where her husband died, and her husband was the person who handled all of the business before he died. And this person did not understand what was going on. And then after he died, everything fell on her lap to take care of, and she wasn't able to do so. And so she wound up in eviction court. Sometimes you might show up in eviction court for things, activities of guests or friends or your family members for whatever reason, not necessarily for any activity that you've done. So you could be here for a number of reasons. And so I just want you to understand that. Also, as Judge Hunt was saying, and everyone else is saying here from the judiciary, we look at matters and we try to dispense justice and be fair and equitable. But one thing, if you look at the scale, whenever you see judges, you see a scale with balancing things. And I like to look at the scale to say we're balancing justice and mercy, because sometimes you have to look at both of those things when matters come into the eviction court. The eviction court is a court of summary proceeding. What I mean by that is that it's a court that's monitored by or governed by statutes for the most part, but you're not going to be here a long period of time. You can go into some other courts, you can be in there for years. You're not going to be in the eviction court for years. You're going to be in the eviction court for some months. We don't have long drawn out discovery issues and things of that nature. We don't drag these cases out. So matters happen here relatively quickly compared to some other courts you go into. All right, but with that said, we do try to be fair. We try to listen to everyone, but to talk about eviction specifically, all eviction court cases coming in Cook County, not necessarily, well, particularly Chicago, all new eviction cases come through my courtroom 1302.
I'm sorry, Judge Wright. Some of the attendees are stating that they can't hear you speak. So if you can turn up your mic possibly.
Yeah, I've had that issue. We talked about technical difficulties. We've had some technical difficulties around here, so I'll just try to speak a little bit louder, see if that helps. In fact, our Zoom went out yesterday in the middle of court, and so we were out for about 30 minutes. So that happens sometimes. Can you guys hear me now? Is it a little better? All right, well, I'll keep going. Hopefully you can hear me better. So anyway, all cases come through 1302. All right, we evaluate all the cases, but when you come through 1302, please don't stress out over it, because there is no trial when you come in on the first day. In fact, if you come into our court and you're self-represented, or sometimes we call pro se, in all likelihood, you're going to be referred to what we call as an early resolution program. In the early resolution program, you're going to be able to get free legal service. The whole point of the program is to see if we can get you guys to resolve your case without having to go to trial. You're usually referred to the early resolution program for 28 days. And so within that time, you'll talk to people in carpos and other free legal agencies that can help you, that can advise you. When we come back, we're told whether or not you're able to reach an agreement. If you're not able to reach an agreement, then your case gets transferred out of here to another trial court, which you may not see another judge for another 2 or 3 weeks, or if not longer. So nothing happens. If you are here on the day that your case comes before the court, nothing will happen to you. There's only bad consequences when you do not appear. And when you do not appear on a second time, because if you don't appear on the first time, we continue it out for 2 weeks. And for the plaintiff to notify the defendant, they need to be here the second time. Now, if you're not here the second time, there could be an eviction order entered. But if you are here, more than likely nothing is going to happen on that day. You're going to get some information about your case. If you're self-represented, you're gonna get some free legal services. But one thing I want to tell you, and I don't want to take, we could spend hours going over the statute that covers evictions in Chicago. And if you don't know, Chicago is a tenant-friendly jurisdiction. So the law kind of leans toward tenants, but that does not, you shouldn't take any comfort in that, because a lot of things can happen. But one thing everyone should get, if you're going through evictions, landlords and tenants, there is a copy of a summary copy of the Chicago Residential Landlord and Tenant Guide. All right, it's a book like this, a pamphlet. You can go to City Hall, room 121. That's 121 North LaSalle. I guess it's room 107. They have these pamphlets on the wall. You should get a copy of it. You should read it. It's a quick read, doesn't take you very long, but it summarizes the laws that cover eviction. And so as Judge Hunt says, as other colleagues have said, knowledge is power, because to have that knowledge, to understand whether or not somebody did something correctly or not, can help you in your case. And so you should get a copy of that. Also, the two things that we look for mostly at the beginning is whether or not the defendant or the tenant had been served properly. And because without service, the court does not have jurisdiction, and whether or not the tenant has received notice of anything. So both of those concepts are very important to our court. So you need to understand that, and you'll get that out of that pamphlet. You should read that. But as I said, it's a very technical courtroom, but everyone comes in, and we do have self-represented litigants all the time, and we make it through it. So don't stress out when you come to this court, because nothing's going to happen the first day. I just need you to be here and pay attention. As Judge Blakely said earlier, we're here on Zoom primarily. We have not opened up the court fully. So you need to understand how to operate your Zoom device, because if we call your case and you do not answer that you're here, then you're going to be considered absent. And that may just be a matter of you not unmuting your device. So you need to understand how that works, because you need to say that you're here so that there are no bad consequences when we call your case. Like I said, I could go on for hours, but I'm not going to do that, because my big show, Judge Lyle, is coming up behind me with foreclosure. Well, she's shaking her head, but she understands. Again, I want you to get a copy of the Chicago Residential Landlord Tenant Guide. I mean, that will save you time. That will give you knowledge that you need, both for landlords and tenants, because I have landlords coming in here. Sometimes they come in and say, well, I can do this by myself. I don't need a lawyer. But what happens is when the defendant gets a lawyer, defendant has a lawyer and you don't, they may be able to shred you apart. So you need to understand what's going on here, all right? If you have any questions, please put them in the chat. I'll try to answer those, and I'll turn it back over to Judge Blakely.
Okay, we do have a couple questions regarding evictions. The first question that we received, it says that evictions occur outside of Chicago. What about the county rules, and how do they differ?
Well, again, Cook County and Chicago are pretty similar. Now, outside of Cook County, they do a lot of different things than we do here. So I can't tell you exactly what their procedures are. But if the property is located in Cook County, and particularly in Chicago, we have specific rules on how we deal with things. For instance, in Chicago, if your case comes up, they cannot get attorney's fees in Chicago. In Chicago, there's a certain amount of notice you have to give tenants when you're filing an eviction notice. Those aren't applicable to outside the county. They have their own rules.
Thank you, Judge Wright. There are a few more questions. Currently, how long do evictions take during the pandemic or since courts have reopened?
Well, that's actually a good question because when COVID started, which was in 2020, March of 2020, cases were pushed out for months on end. Now things have kind of picked back up. I would say from the beginning to end, eviction cases are getting resolved within 4 or 5 months. The sheriff tells us that if they go out to do an eviction, they're doing that within 3 to 5 weeks. I'm not certain if that's accurate, but that's what they're telling us when they do the evictions. And when they do evictions now, if that so happens, it's a little different here in Cook County and the city because they don't put things out on the street or do anything like that. The only thing that the sheriff does is they will go to a property, they will escort people out of that property. They then will allow the property owner to change the locks. That's how they handle things now. They do not put things out on the street. They then allow that property owner to make an arrangement with the tenant to remove any belongings in there.
Thank you. The next question in the chat is, can you please define a squatter?
Well, what we see as a squatter is someone that's on a property that does not have a lease, never had a lease, do not have any authority to be on that property. And that's actually an interesting question and almost related to something that you said, Judge Blakely, earlier about scams that take place. Sometimes we've had cases in the courtroom where people have gone on Craigslist and seen a property, looks good, they rent the property, only to find out later that the person they rented the property from did not have authority to rent that property to them. And so when the landlord shows up to the property may be undergoing renovation or something like that, and the property owner shows up and they find someone on that property, and then that person said, well, I have a lease with so-and-so, but that was not a person that had authority to lease that property. And a person cannot give you any more authority than what they have, but you've paid them money. And after that, you never hear from the person again. Well, that's a sign that that person didn't have authority to rent that property to you. And so what we try to do, we try to get the parties to talk, see if they can resolve their matters. But you got to watch out for that. You got to watch out for that. We've had people get evicted and break back into the property to stay in the property. Those would be considered squatters. All right. If you don't have any authority to be on that property, then you may be considered a squatter.
This is the hot topic. There are a couple more questions for you, Judge Wright. One question is regarding service. What happens if a tenant intentionally avoids being served?
Well, it happens all the time, but there are ways to get around that. When you file a complaint, you pay for the sheriff to go out and serve. If the sheriff is unable to serve, then we'll give you permission to get a special process server. They're a little bit more diligent about going out and getting service. If you can't get service through the special process server, then you may be able to get service by publication or what we call posting. Now, if you got service by publication or posting, that only gives us authority or jurisdiction over the property. You would not be able to get back rent or anything like that, but you can get your property back.
I do see a question asking I will type in the information on how you can receive the eviction law pamphlet. They didn't quite get the room to go to in City Hall, so
I'll put it in chat as well, where you can go and get that. I mean, it's very helpful. It might cut a lot of time out of everything that you do, because Chicago, particularly Chicago, is very specific about some things. Landlords, you cannot lock out people. You cannot change locks. You cannot turn off utilities because you face stiff penalty if you do any of that sort of stuff. You cannot take any self-help action. All right, you have to go through the process.
And lastly, can a squatter be served a notice to vacate immediately?
Well, squatters can be served notice to appear in court. The question is whether or not squatters will have any rights to continue to go through the process. Now, what we tend to do is we'll send everybody to a trial room, but you may not have much defense if you're a squatter.
I think I saw one more regarding the Chicago. I'm sorry. Does the Chicago residential landlord tenant ordinance do landlords of owner occupied properties with less than 6 units have to abide by the Chicago residential landlord tenant ordinance?
No. No, if the property is, if the owner lives on the property and it's less than 6 units, they do not have to comply with the Chicago residential landlord tenant ordinance. However, there's still statute and maybe court orders and things like that that they may have to follow, but not the Chicago landlord tenant ordinance.
Thank you so much, Judge James Wright. We'll now move on to foreclosure, and that will be presented by the Honorable Fredrina Lyle. You're muted.
Under these, you can tell we've had difficulty since June of last year, but I want to start off by saying the courts have been open. The courts are open today. They were open last week. We have been operating on Zoom. The building has not been open for people to come in and see judges personally, but we have been open since June, maybe May of 2021. So we've been working. The second thing is that unlike Judge Wright, who they have a handbook for you that says these are all the things you need to know. The city is very, very tenant friendly, and they have the landlord, the tenant ordinance for the city of Chicago that you can just pick up and see what your rights are. There's not such a document in mortgage foreclosure. And so I began with that by saying, you need to talk to a lawyer. The mortgage foreclosure is a process that was created by statutes. And how are statutes made? People go down to Springfield and they have lobbies that go down to Springfield and they create laws, get the legislators to create laws. As is the case in many different areas of the law, poor people don't have lobbies. So the laws that were written were not necessarily written for you, the individual homeowner. There are protections that have been built in over the years, either through the legislature or through the courts and the way they define the law, but it is a very technical process, probably second only to bankruptcy, which is really technical. You need to get legal advice, and if you cannot afford a lawyer, there are some agencies that will assist you, and we also do have a help desk in mortgage foreclosure, and hopefully we will be reinstituting our mediation program, similar to what's going on right now in the eviction program that was working in the foreclosure division before the pandemic, actually maybe a year before the pandemic. There were some financial issues and they discontinued it, but that's a really good program that we're trying to get back. Number one, I think you've heard 3 judges so far tell you to come to court when you get served. You get a notice saying something is going on and your name is on that piece of paper. At the very minimum, show up so that you can make sure you know what it is that's going on. Don't let Pookie tell you, girl, you don't have to worry about it. Don't believe that if you ignore it, it's going away, because that doesn't happen. So come to court. You get service of summons. Within a certain period of time, you're expected to file an appearance and answer. If you do not file that appearance and answer because you've ignored it, because you think it doesn't matter to you or someone told you don't bother, within that period of time, the bank will be filing a motion asking that you be held in default for failure to appear. And by your not appearing, by your not showing up, it says to the court, Maybe they just don't care. Maybe they've already abandoned the property. Maybe they've moved. And you are sort of waiving your right to participate, and the bank or lending institution, because there are many investors out here, so it's not just banks, they will ask the court to fast track the litigation, and it will be fast tracked because you won't be there saying, wait a minute, Judge, I didn't get served. Judge Wright talked about how service is very important. It's equally important in foreclosure. They've got to come out and serve you with a summons, and there are various ways. People come in frequently and say, well, nobody ever put that in my hand. And it doesn't require that they put that in your hand. There's some, again, very specific rules as to how someone can serve you, but they can also serve you if they're not, they can, if you're in their presence and they say, this is a summons for mortgage foreclosure, and you turn around and walk away, they can drop it in front of you, and that's service. They can serve a person over the age of 14 who is in your house who takes it. So there are a lot of different nuances that we really don't have the time to go through today. Main thing, going back to where I started from, talk to a lawyer. You get served, come to court. They can serve you by publication too, and that's the one that's the most troubling, because you may not have any notice that the proceeding is going forward, because they have published it in a newspaper of general circulation for a 3-week period of time. Usually that's the Law Bulletin or a small neighborhood newspaper. It may not be a small neighborhood newspaper in your particular area, so you may not have seen it. However, you know in most instances that you have not paid the mortgage. You know in most instances that you owe the mortgage, and you should be trying to find out, well, what can I do? We've had many people who were behind, and our courts are no judgment zones. When you come to court, I don't need you to say, well, Judge, all these horrible things happen. I assume that something bad happened. I assume that something happened and things sort of spun out of control. I don't think that you are just a deadbeat or decided one morning, well, I'm going to just give up my house and not pay the mortgage. We don't assume that. We think that things happen to people, and we want you to come because you will have an opportunity to talk to us, but we may be able to direct you to some services. If you get behind in your mortgage right now, I'm saying to all of you, so you can tell your friend and you can tell the people on the boat, you can, which they shouldn't be, but if they're on the boat and they tell you they got problems with their mortgage foreclosed, that's about to be more, they're behind on their mortgage and they're on the boat with you, you need to tell them to go home. And then secondly, you need to tell them to get legal advice, because they may be able to sell their house. They may be able to work out a loan modification. There are things that they can do other than just sit there and wait until they get a final notice that the property is going to be sold. So you come to court the first time. You come to court, we do what's called a case management. The summons tells you to appear on a certain date at a certain time. And at that time, the judge is going to inquire, A, have you spoken to an attorney? B, are you trying to save the property? Because there are people who've said, Judge, this is a property I had with my husband. He's died. I'm going to move on my children. I can't handle it alone, or that we owe so much right now that I would rather take the rest of our life and rent and enjoy our senior years. We don't want to fight for these bricks. People come in and they surrender the property. Many times it was an heir property, and all of the heirs have properties of their own, and they're like, no, we're not interested. So in the first court appearance, many people say to us, Judge, we can't do it. We don't want to. We're not going to try to defend this, but we'd like to get a graceful exit. Then we talk to them about what graceful exits are and how they can accomplish one if it's possible. If you come to court and say, Judge, I've lived in this house for 20 years. I want to stay here. I got behind and I just really need a little help. Then we're going to talk to you about some agencies you can talk to. We're going to explain to you legal assistance that you possibly can get. And it's all possible because we can't guarantee that on any date and time, any agency can accept your case, because we don't know what other cases they're getting from other courtrooms in terms of referrals. And we can say to you, contact the bank and work out fill out an application for a loan modification. So they have what we refer to as LMAs, loss mitigation affidavit applications, and you fill it out, and then they have people that will talk to you about whether or not you have sufficient income to rework your loan. Maybe you can't bring it current, but maybe they can work out something with you that you can pay a little bit more and they will attach the balance to the end of the loan. So instead of having a 20-year mortgage, you might have a 23-year mortgage, but you'll still be in the house. During the moratorium, the courts were not allowed to proceed to foreclosures, to judgment, but banks did still file the foreclosures and people still came to court. And if they were seeking to work things out, we worked out those agreements and those cases were dismissed. If they were not and they are set for sale, meaning there is no judicial basis to deny the foreclosure, those can proceed now. So if you have been operating under a forbearance and you have not worked out a modification of your loan with the bank, you need to immediately check into the court files, and you can do that by going to the clerk of the court's office online. You don't even have to go down there, and see what the status of your loan is, see what the status of your mortgage is, as opposed to waiting until someone comes with the notice of sale saying that your house is going to be sold and the third party might have bought it. But quickly, process is you get a summons, process is you have to file an appearance or answer. At that point, if you have a lawyer, they'll do discovery. They will go back and forth with the other lawyers, reviewing documents to make sure that the bank's attorneys, and I keep saying bank, but it's not just banks, it's private lenders, it's other entities, credit unions, anyone that loans you the money, but for the purpose of the conversation, banks. The lawyer will check to make sure they comply with all of the statutory regulations regarding giving you a notice that, hey, you're behind and you have so many days to catch up. They have to do that notice before they can accelerate. And accelerate means I gave you an opportunity to catch up on your mortgage. It blew me off, didn't do it. And now I'm going to call your entire balance due, meaning you may have had a $3,000 deficiency. That may be what caused that letter to come out, a couple of months on a mortgage. But now, because you have not come up with the $3,000 or worked anything out with the bank during that period of time, they're calling the whole note due. And that can be $100,000 or more, depending upon the value of your house. So the lawyers will check that for you. Of course, you can check that, and it's not required. We have people that do come into court and try to represent themselves, and some people are successful at doing so. Others are not so successful. So I would just recommend that you talk to a lawyer, because you are up against someone who's got a law school degree and maybe has worked in mortgage foreclosures for years and years and years. So it's not the ideal situation, but it can be done. After the discovery, then the bank comes in. If there is no issue, genuine issue of material fact, the bank will come in and file what's called a motion for summary judgment. And that's basically what it says. Judge, we lent them the money. They didn't pay the money. This is an affidavit by a representative of this bank showing all of the details in terms of how much they owe, because not only do you have that first $3,000, if it takes 2 years to go through foreclosure, now you've got attorney's fees, you've got interest on that $3,000, you've got principal that's been increasing because now you've got inspection fees. Once the property gets in default, they send people out to inspect the house. Doesn't mean that they're coming inside. They're driving by to see that their house is still standing. You've got summons fees, you've got attorney's fees, and now that $3,000, depending upon how long it is, may be $10,000. If you keep a case in court 4 or 5 or 6, 7 years, it may be $30,000, $40,000, because in addition to your monthly note, the bank is going to pay your taxes and your insurance whenever it's due, because that is their security for that loan. So you go in and borrow the money, you give them the right in that mortgage documents to pay any charges that are assessed against your property. City comes in and says they got building code violations and they fine you for that. That goes against your mortgage and it's added to your principal. They can then attach an interest to interest will accrue against any money they paid for taxes, any money they paid to keep that property insured twice a year, any fines that have been incurred against you by the city, and legal fees. So you have people who really didn't owe hundreds of thousands of dollars have been faced with a judgment, which is the final document that is hundreds of thousands of dollars. So A, go to court. B, talk to a lawyer. C, talk to the judge. D, if you can possibly work something out with the bank, that is the best thing to do, because you can negotiate your terms and just keep your property, stop the litigation, because as the litigation continues, so does your cost. But any money that the bank forwards and advances on your property is attached to that mortgage. And when you sign the mortgage document, you agree to that. So it is, people do save their homes in our courtroom all day, every day. They work out agreements. Sometimes they can have a graceful exit because they can't work out an agreement, but they may be able to sell the property. They've got equity in the property, so they can sell the property and wipe out the debt. If the bank has to sell your property, it's a distress sale. They're not required to sell it for whatever the BPO is. They sell it to the highest bidder, and you may have what's called a deficiency. There may be something between a dollar amount between how much they received and how much you owed, and then the bank can come after you personally if they got personal service. So it's very complicated. It's a very scary process for many people. It won't be as scary if you come to court. It'll be a lot less scary if you talk to a lawyer. And there are some free legal services available, not many. But the last person you want to talk to about how to handle your mortgage foreclosure action is the guy in the barbershop, the lady in the nail shop. You don't want to take legal advice from those people. And you don't want to take legal advice from people who tell you, and you can find them on the internet, we've got these magic words that you can file, and you can say you got a land patent on this property, and we can, all sorts of things are going on, and you've paid them, and at the end you have not only paid them and taken money that you may have been able to pay the bank, but you still lose your property. So don't listen to third parties. Talk to a lawyer. And again, I thank you guys, and we've got wonderful information here. People that need to hear this more than likely aren't on the panel tonight, but you've got friends, and what we hope when we come out to communities is that you will be like our talking drums, and you will tell your friends and spread this information, because it may be somebody you know, neighbor, maybe somebody in your family that needs to hear what you're going to hear today. So thank you.
Thank you so much, Judge Lau. At this time, we'll move to a question and answer period. So if you have questions, please use the question and answer feature, or you can drop your questions in the chat. There was a question that was sent via YouTube because we are streaming live. And that question was in regards to bankruptcy. So Judge Hunt, the question is, while in bankruptcy, are you able to make payments to your creditors to expedite the process?
Yes, you can. But what typically happens in bankruptcy, so if you're in a Chapter 13, you are paying off what's called your pre-petition debt. So any debt you incurred before you filed that bankruptcy petition, that's what you're paying off. And so you're making that payment to the Chapter 13 trustee to pay to those creditors. But then you have post-petition expenses. So your regular expenses that you're continuing to incur, you would continue to pay those off directly as well. Should you make separate arrangements to pay more to creditors than what your confirmed Chapter 13 plan requires you to pay? Probably not. But there is a concept if you are in a Chapter 7. So you can voluntarily repay a debt, any debt, even if your personal liability is discharged. You reaffirm the debt, meaning you sign a new agreement saying, I agree to continue to pay this debt. So people operate under this mistaken assumption that you file a Chapter 7, all your debts get wiped out, you get to keep your house, you get to keep your car. Well, not really, because if you don't continue to pay on those debts, then your home can be repossessed, your car can be repossessed. You won't owe personally after they're repossessed and sold. So that personal liability, as Judge Lyle was talking about, if there's a deficiency after the asset is sold, then the bankruptcy will discharge that. So you don't owe, but that does not mean that you get to keep the property. The bank will come and take the property. Your car will be repossessed immediately. So, I've heard that myth from people that I filed a bankruptcy and I got to keep up. No, you did not. You had to reaffirm that I will continue to pay this debt. And if you don't continue, if you reaffirm, and the court has to approve that also. So you say, I'm going to continue to pay for this house, this car, and you don't. Now the lender can come, take your house, sell it, take your car, sell it, and the debt is not dischargeable. You owe the deficiency too. So yes, you can continue to pay. The bankruptcy code specifically says you can pay who you want to pay, because sometimes, for example, if you work for the city of Chicago, there's some debts you cannot discharge. You have to pay your water bill, or it's a condition of employment, I've been told. So there are debts you can agree to pay, but you should have a really good reason for doing that and make sure that you're protecting your interests.
Thank you so much, Judge Hunt. If there are any other questions that you all want to drop in the chat or Q&A, we will be happy to answer them. We do have a few more minutes before our series end for the night.
Judge Blakely, can I pick up on just a thread that was echoed by Judge Wright and by Judge Lyle?
Absolutely.
The notion that there should not be a stigma attached to this. There is definitely a stigma attached to an individual bankruptcy. I have had people I know show up before me, and it is very awkward and it is very uncomfortable, not for me, but for them. Because unfortunately, a business can file to reorganize and nobody thinks twice about it. It's a great thing. You're reorganizing, you're, getting rid of certain debts. You're not paying particular creditors, or you're paying them less than you owe. And there's no stigma attached to that. Even though the same individuals who were running the company before and, got into debt are going to continue to run it. But with individuals, there is definitely a stigma. And I think it's important for us as a community to be okay with the idea that sometimes bankruptcy can be a way to obtain a fresh start. And you should not feel like, I can't do this, or I shouldn't take advantage of this opportunity, because it is a legal process and it is there for a reason. I hear all types of stories. Things happen, lose a job, get sick, got to take care of a parent, like all types of things. And it is common and it happens, but there should not be a stigma attached to it. And if you need this, then take advantage of it.
Thank you. And if there are no other questions, I'll give each of the panelists to give some closing words or any other information that they maybe forgot or want to share with our listening audience. So we'll go back to Judge James Wright, if there's anything else that you would like to add.
Well, there are some free legal services out there. Like I said, if you come into the eviction court and you're not represented by an attorney, whether you're the landlord or the tenant, we're going to send you to the early resolution program where you can get some free legal advice or options on how to resolve your case. If you're coming in here on a commercial plaintiff or as a defendant, you're going to have to get an attorney. You cannot represent that commercial establishment. All right, you can't do it yourself. You're going to have to get an attorney, as Judge Lyle said. And you need not listen to your friends and people at the barbershops and all these other sort of places. I have family members coming in all the time trying to evict their other family members or, just related people. I had one particular case where I wound up brokering I'm sorry, my video went out, but it's okay. I wound up actually getting a good agreement for the tenant. And it was a really good agreement, I have to admit myself. But he had his sister in his ear who did not even live here. His sister lived up in Wisconsin, but she was the cause of the reason why he was getting evicted. And she kept whispering to him, go to trial, go to trial, go to trial. And he was, he didn't know what he was going to do. And I couldn't tell him whether or not to accept the agreement. It was just a good agreement. He eventually said, well, I'm going to go to trial. I'm not going to accept that agreement. He went to trial, and needless to say, he did not win. And so he was evicted. And he had a really good deal, which would not have given him an eviction on his record. So you need to understand who you're listening to.
Judge Lyle.
Let me just add that it's ironic that the three of us are here because our courts really interrelate. I mean, my court is directly affected by what the bankruptcy court does if a defendant in my court, the borrower, the homeowners, if they go into bankruptcy, if they get a stay, everything stops. But again, they then have to either reaffirm the debt and decide that they're going to continue to pay the mortgage or work out an agreement as to how they're going to pay the mortgage in 13. But they're making payments and they say, yes, I'm trying to save this property. And so that stops everything. And we wait to see what the bankruptcy court comes up with. And if there is no agreement and we can't resolve anything and there's no saving loan modification and the case goes through to judgment, the property will be sold. And for tenants out there, if the property is sold, strike that, I'm gonna go back a little bit. They will come in and ask for a judgment, allowing them to sell. And if they've gone through the entire process and everything has been done properly, we will give them an order appointing a selling officer, and there will be a sale at a public auction, not out on the corner, but it will be at a company that does these public auctions. They then have to come back to my court to ask me for possession. They come back after the sale and I have to approve to make sure that the sale has been conducted properly. If it has been, they've given everyone the proper notice, then we would give them an order approving the sale and possession at that time. And that's the only time we give them possession. So from the time that the foreclosure is filed until the end of the case, the owners are entitled to remain in possession of their home. Once the sale occurs, I will enter an order, usually 30 days, because that's what the statute allows, but we're a court of equity. And very frequently, if someone shows up and says, Judge, I tried, I didn't work out, but I need just a little bit more time, then we have the ability to, and very regularly do give them a extension on that 30 days. 60 days probably is the most that people will get without some extraordinary circumstances. If we have extraordinary circumstances, I'll try to get the lawyers for the bank to agree, and we have extended the stay. The reason that I said this is relating to Judge Wright is that if there are tenants in that property, nothing that I write on that piece of paper, nothing that's on the document presented to me that I sign affects the tenants. It only affects the owners. So if I have tenants that will come to court and say, wait a minute, whoa, there's a man outside and he's tacking something on here. And we found out that the property's in foreclosure. How does that affect us? And I explained to them what the foreclosure process is, give them a general idea about how long it will take to get to the end, and say to them, if you are in there after the sale occurs, they have to then go see Judge Wright. They have to file an eviction to remove the tenants. My orders affect the people that we confer jurisdiction over by virtue of that summons or publication. And that is the owner and the occupants that they can identify at the time, maybe the owner and the spouse and some other named people. If your name isn't on that notice, if your name is not on the complaint, it does not affect you. One more thing, because sometimes they will add the tenants, but we cannot, we have no jurisdiction over the tenants. And so if you have tenants in a property, if you are a tenant, you know somebody that's a tenant in the foreclosure property, the order of sale doesn't affect you. The order of possession does not affect you. But when I have tenants that come in, I said, you know, you probably want to start looking for someplace, because of the property's in foreclosure. That means they are not picking up the garbage. They're not maintaining the property. And you don't want the sheriff to come and put you out at the end of an eviction process. So make it your decision as to when you want to move.
And if I can add to that, Judge Lyle, if there is a notice of mortgage foreclosure, they have to notify the tenants of this. And particularly if you have not signed a lease yet, and if there's a notice of mortgage foreclosure, by law, they have to notify the potential tenant that this exists.
Thank you, Judge Wright and Judge Lyle. We have one final question. There's a question: are there any financial resources for landlords since the ERAP and RAP programs are over?
Well, the ERAP program is actually still in existence. I mean, we have cases every day where people are filing for rental assistance. So that still exists. You can also go to, I'll put in the chat room, Carpo's Legal Aid. They have you can maybe get some free legal services from them, and I'll put their contact information in the chat room. As Judge Lyle said, there's not very many places that you may be able to go to. And again, Chicago and Cook County is a more tenant-friendly environment. So you may need to consult with or hire an attorney. But for the most part, there are a few resources, but not very many.
And I encourage every homeowner to go on the website and contact the Illinois Housing Development Authority. And they can see if there are still assistance. And some of the programs have not spent all the money. So please research it before you just assume that you can't get any help. So that's, I guess, the best we can tell you there. You have to do some work out here to get the outcome that you want. And sometimes that just means showing up in court. Sometimes it means getting on the computer and checking out the Department of Housing for the city of Chicago, the Department of Housing for Cook County, the Department of Housing for the state of Illinois. And then you might be able to get the assistance you're looking for.
But one other thing, always remember, parties should talk. Maybe you might be able to resolve your case. You know, landlords should talk to the tenant. Sometimes the communication just falls off, and you may be able to resolve your case without having to go to trial. So try that. I mean, in fact, City of Chicago requires a 7-day period where you show that the parties, the landlords and the tenants, have had conversations about resolving their case.
And there is a period in your mortgage that the federal government requires that you have to be offered loss mitigation. They have to, if once you're 30 days behind, they have to make an attempt to have a personal meeting with you. And the reason I say an attempt is because many times people are too embarrassed to even have them come out and talk to them. But they have to make an attempt. They have to file an affidavit when they come to foreclosure saying that there was loss mitigation efforts made with the owners, what they qualified for, what they offered, what they were not able to offer because of their finances. So yes, talking is good. Filling out those forms, because it's all about money. I tell people when they walk in the door for the first time and when they're there for the 40th time, the bank doesn't want your property because everybody comes in, they're trying to steal my house. All they want is their money. It's all about money to them. They do not want the house, and that's why they sell them at the end. So rather than have to have a property that's vacant, if they can work it out with you, many of them will. But if you've been calling, cussing everybody out, maybe they won't.
And can I just add, show up and assert your rights, because many of these eviction and foreclosure actions wind up in bankruptcy court. And there will be a point of no return where the bankruptcy court can't help you either. So once the property is sold at a foreclosure sale, there's nothing that the bankruptcy court can do. It's gone. If you are a landlord and a tenant files for bankruptcy, come in, show up, and ask us to lift the automatic stay so that you can then go back to state court and continue to litigate. And if you're trying to get that tenant out, file a proof of claim in the case so that you at least get some payments on what the tenant owes to you. So it really is a matter of understanding your rights and using your voice to protect your own interests. There are legal aid organizations out there, but there are not enough. You're going to have to do it yourself.
Thank you so much. I want to just send a special thank you to everyone who attended tonight. A special thanks to all of our judges on the panel, the judges behind the scene. A special shout out and thanks to Judge Thaddeus Wilson and Judge Alan Walker. Those are tech savvy judges. So they're working behind the scenes. I just want to stress the importance of the collaboration with the National Panhellenic Council. We really appreciate that. There are many of us, a part of the Illinois Judicial Council, who are members of the National Panhellenic Council and members of the Divine Nine. I didn't say before, but as you can see with my pen, I am a member of Zeta Phi Beta Sorority Incorporated. And Judge James Wright is a member of Kappa Alpha Psi.
Yo.
And you'll hear from more of us throughout the series. We really appreciate it. We hope that you have taken away something that either benefits you or that you can share with someone else. Thank you all for attending. We'll definitely repost and ask that you share our future series. And with that, I'll turn it over back to our president, the Honorable Judge Benita Coleman. Thank you.
Thank you, Judge Blakely, and thank you for working with the National Panhellenic Council of Chicago and putting this seminar together. Thank you again to our judges. Thank you again to Mr. Whiteside for assisting us with this. Again, we hope that you have taken away something, taken away information that you can use to benefit yourselves. Two of the things that I just want to reemphasize that the judges have said to you: appear in court if you get a summons and a subpoena, and don't rely on non-credible resources, your friends and Pookie and family members. Everybody's situation is different. You have heard from the experts here, and they have provided you with valuable information and valuable resources. Please utilize them. Again, thank you for attending, and we will see you next week when we talk about domestic relations and domestic violence.
Thank you, everyone. Have a good night.
Good night.